Kia ora whanau, welcome to the fourth episode of the Paul and Henry show. That's me and Henry talking about stuff that you should probably know. In our second episode, we did decision making. And in that episode, we talked a wee bit about evidence and what we needed to do to support our decision making. So today we're going to have a chat about evidence. It's a pretty exciting subject, and we've got some special actors coming in to help us.
We do, so watch out for that. So evidence is key to what we do, and we're going to focus today on gathering evidence. But first of all, Paul, what is evidence?
Very good question, Henry. I think about it this way. Evidence, quite simply, is a thing that proves a fact.
Right. So evidence is not the fact itself.
No, evidence isn't the fact itself. Evidence is the thing or the things that prove or perhaps disprove a fact.
Yeah. So maybe we should start with a case study, which we can talk about.
Sure.
So if the fact that we're trying to prove is that someone has been keeping false logbooks.
Yep.
So that is the fact we're trying to establish.
Yeah.
Now, what might be some examples of evidence of that fact?
Okay, so there's lots of different types of evidence, and it might be important to think about, in this case, we're talking about evidence that we want to ultimately prove in court.
Yep.
Right. So, firstly, we need to establish whether or not this allegation is true, and we need evidence that we can give to a decision maker where they can be assured that, hey, I'm making a good decision based on all of the evidence that's available. So, the sorts of things you could look for is logbooks is obviously the big one. You might even get into collecting other documents that are related to the logbooks. So, if somebody's saying that they weren't driving at 9 o'clock at night, but there's fuel receipts or there's a port document from 9 o'clock at night, that would prove, perhaps it would go towards proving that the logbook was incorrect.
Yep.
You could also get interviews from, oral evidence, interviews from witnesses. They might be people who fueled up the truck, spoke to the driver, could be the driver themselves, could even be the person who the mechanic who works in the yard, any of those sorts of things.
Yeah.
And another big piece of evidence that people often overlook is the electronic trail. Always say follow that electronic trail, like everything we do, we use our phone, we're creating an electronic trail with text messaging, with alarms, with emails. When I say alarms, I mean, when you set your alarm in the morning to get up, all that sort of stuff creates an electronic trail. And CCTV footage.
Yeah. There's
just so much of that stuff around these days, So if you had a logbook that said, hey, I wasn't driving at 9 o'clock at night, but you've got them consistently going through the roundabout or past the service station or wherever there might be a camera, all of that is good evidence.
Yep. So in that example, that's helpful for me because what I always like to do with people is go, you've got a lot of evidence and it actually proves a lot of different facts.
Yeah.
For example, the weighbridge receipt at 9 o'clock at night is really good evidence of the fact that you were on that weighbridge at 9 o'clock at night.
Yeah.
But always come back to what is the fact that we're trying to prove? We're trying to prove that the logbooks are false and they've been deliberately keeping false logbooks. So the evidence can help you prove that fact, or it can help prove other facts which point towards that fact.
Yeah. So
and it's just important, I think, in your mind to keep those things clear.
Yeah. And sometimes you're proving a negative.
Yes.
So someone says, no, my truck was parked up in the yard. And you're trying to prove, no, that wasn't the case. So you're proving the negative of the truck being in the yard.
Yeah.
So anything you can find that proves the truck wasn't in the yard is almost a negative fact.
Yeah.
I don't think we should get into a conversation about circumstantial evidence, but we should touch on it very briefly.
Sure.
Because what we're talking about there is circumstantial evidence. The fact that there is a document that says you went through Wayrite at 9 o'clock at night when your logbook says you're in the yard is just circumstantial evidence. If you had a photograph or a video, that starts to become more concrete evidence that you can really go, no, this is definitely the truck or the driver, or a stop by police and they've recorded their details and it gets a bit stronger.
Yeah. And just to link back to the previous video, we talked about proving a negative briefly, which is that if you have really good systems that you consistently use, then that is often the best way to prove a negative because you can go, well, every time we receive money, we follow this process and we issue a receipt. There's no record of the transaction being alleged. Therefore, we think we've proved that transaction didn't exist. Anyway, when do we need evidence?
Hang on, mate. Can I just make a couple of comments on what we're talking about here? Because this is important. Two things I'll always say. Know the reliability of your evidence.
Yes.
So if they say, no, a truck was parked up in the yard at 9 o'clock, and we say, no, here's a weighbridge record of you going across the weighbridge at 9 o'clock at night, go and make sure that the weighbridge time was right.
Yeah.
Because you wouldn't want to be sitting in court and find out someone say, oh, we didn't adjust it for daylight saving.
Yes.
Which actually happens, so always know the reliability of your evidence.
Yeah.
And the other big point is always have two pieces of evidence for everything you're trying to prove.
Yes.
So that if one falls over, gets thrown out, or is a bit weak, but the more you have, the better. But at a minimum, try and have two.
Yeah.
So if you've got the weighbridge document and you understand the reliability of the timing, and you've got CCTV footage from the BP service station down the road, and you understand the reliability of that timing, you've got two pieces of evidence that aren't related to each other.
Yeah.
But they, it starts to build a pretty strong case.
Yes. Okay. So we've talked about what is evidence. It's stuff that helps us prove a fact. And it's good to have clear in your mind what's the fact you're trying to prove and what's the stuff that points towards it and proves it. When do we need evidence?
So absolutely we need evidence when we go to court. We can't go to court without any evidence that, our case wouldn't stack up. But if we wind that right back a whole lot, we need evidence in varying degrees. So if we decided to go and, let's say, for example, we had a tip-off about that operator, is that evidence? No, it's not really. It's just a tip-off. So then you need to start collecting some evidence. Firstly, to go, is this allegation right or not? So you would set about starting to collect some of that. So you're going to need, and as you start to collect that evidence, you'll start to figure out, actually, there's nothing in this. It's a false complaint or the mistaken complaint.
Yeah.
Or actually, no, there's a lot more to this case, and that might direct how you plan your inquiries.
Yeah.
So you'd start to go, let's collect more. You absolutely need evidence when you're going to make a decision.
Yes.
I can't think of what it's called if you make a decision without having evidence. Probably unlawful and arbitrary, but you shouldn't do it. You should have lots of evidence when you make a decision. And if you know the reliability of it, when you're pushing your set of facts, your report, however you might do it, up to your decision maker, and all of your evidence stacks up, it makes the decision-making process really easy because, it's not, if you're looking at something, you're going, oh, look, the evidence is a bit light. There could be a million other reasons why this has happened or not, it's a lot harder to make the decision.
Yeah.
I just had a wee thought then about our first video about natural justice.
Yes.
Some of the best evidence you can collect is from the person that you think might have been responsible for the events that you're trying to prove. And we have an obligation to put the evidence to that person.
Yes.
So it's important too that when you're collecting it, you collect it in a way that is professional.
Yes. And you can share it with them.
You can share it with them in a way that preserves the integrity of that stuff.
Yeah. So for me, obviously we need evidence when we get into court, and most commonly that's when people appeal our decisions into the district court. We never know at the start of a process when we might uncover some pretty bad offending and need to end up prosecuting. But there are a whole lot of other steps before that where we still need evidence for our internal decision making, evidence to guide us in how to run an investigation, and evidence to show somebody in a notice of proposal to say, hey, what have you got to say about this? But the point we wanted to make was not all of your evidence has to be up to that courtroom standard. It's best if it is.
Yeah.
And it's best if you set out with that mindset because, as I say, you never know when something might lead to a prosecution. But if it's not up to that court standard, it can still be useful, functional.
100%. So, sorry, mate, can I just jump in there too? Even more than court, probably the stuff that we deal with on a day-to-day thing would be like, do I need to stop this person from operating right now? What steps do I need to take?
Like an immediate suspension?
Immediate suspension.
Yeah.
It's a safety thing. What evidence do I need to? I've got to have some evidence to support my decision.
Yes.
I can't just do that on I kind of thought it was about right. And that's where things like photographs and notebook entries and, if you're dealing with an operator on the side of the road, you're working with police or whatever, and you're looking at a truck and there's a whole billion things wrong with it, grab lots of photos of that stuff. so that later on when they're complaining that we were bullying them and we were over the top in our approach, we can go, well, here you go, Your Honour, here's a tyre that's falling apart.
Yeah, let the facts speak for themselves.
Yeah, mate, that's the one.
Right.
Here's some welds that are cracked,
Yeah. So how do we collect evidence and look after it?
So there's a little thing called chain of custody. I think it's got some other terms, but chain of custody is the one I use. And that essentially says that everybody who's had possession of that evidence from the time that the regulator has first got a hold of it to the time that it is produced in court, and this is in a court context, you can prove all of the people that had possession of it, how it was stored, any movements. And the reason you do that is quite simply so you can negate any allegations around tampering with it.
Again, this is about proving a negative. If somebody says, well, I think it was tampered with, the way we can say, well, no, it wasn't, is to say, well, we've got a record of who had it and when. There's no opportunity in there for someone to have tampered with it. Now, I hear lots of people talking about the best evidence rule.
Yes.
What's your understanding of the best evidence rule?
There's probably a big legal definition, but the court says if you're going to produce evidence, we want it in the best and most reliable format there is.
Yeah.
So at a practical level, that means if you can produce an original document, produce the original document, don't produce a photocopy.
Yeah.
And that's simply to avoid that allegation of, well, this has been altered somewhat from the original. We haven't got the original, therefore we can't examine whether or not it's correct. Therefore, my client's not getting the right at a fair trial.
Yeah, yeah.
So originals when you can.
Yeah. So really the best evidence rule is about originals, and it's about the best evidence available. Now, we have lots of different powers to take people's documents. Sometimes those powers are that we can take a copy. So if that's our power to take a copy, that's all we can do is take a copy. And that's where the chain of custody is really important, to be able to say, well, this is where I got the original, this is where I took the copy, how I took the copy, and then I took the copy back, and here's the chain of custody.
Yeah, there's a lot.
If we've got the power to take originals, we should be taking originals. Yeah. And that's the best evidence. There's
a couple of acts, I think, where the act says that we have to give the original back as soon as practicable.
Yeah.
All right. Now, I've got a view on what that means.
Yeah.
I think the common thing that regulators fall into is they go, that means I have to give it back straight away. So they take the original, make a copy and give the original back, and then they work off the copy. Now, the reason why you have to give it back often is so that the person can maintain continuity of their business or they can keep operating. So in a maritime context, you have to give the ship's charts back because the ship needs a chart so it can keep operating. You know, it'd be unfair to take it.
Yeah.
And in a RUC context, they need the documents for their tax purposes, for maintenance records and all that type of thing. But what I say is give them the copy.
Yeah.
Like they don't need the original. And if they do get audited by IRD and IRD says, where's your original documents? They will have a receipt from us that says, you know, we've taken the original documents, here's the copy.
Yeah.
And we would have followed the chain of custody properly. So we would have preserved those originals in a way where they are secure and they're not going to be tampered with.
That's right.
And we can give the IRD if they need them.
And that, as soon as practicable standard, you've got to read that with the best evidence rule. So the court expects us to turn up with the best evidence. So it's not practical to give it back until we've been to court and it's all over, or we know we're not going to court.
Yeah. Can I just make a comment around the chain of custody and securing your documents? I don't think we have at Waka Kotahi sort of evidence lockers, or we might have a few around the regions, I'm not sure. But if you're starting to collect evidence in a case, think about how you're going to store that stuff. And it might just be getting a locker that you can store it in yourself and lock the door. You know, that's a really simple thing. If you're collecting big pieces of evidence, sometimes there's a practical thing to that. You know, that might be parts off a vehicle. It might be loads and loads of documents. Then have a chat with your manager about getting some extra storage.
Yeah.
Because there's companies that provide this facility.
Yeah. And take photos of you taking the stuff as well. I think that's important in the chain of custody. Photos of you taking the stuff is really helpful to refute any allegations later on.
And you can never, ever take too many photos.
Yeah.
Ever. Because I know that if I take 500 photos, in amongst that, there will be 10 photos that are just gold.
Yeah.
And the rest will be blurry and rubbish and, you can't have too many. And in this modern age of electronic storage,
Yeah.
You can store 2,000 photos. It's fine.
Yeah.
Just
very good.
Yeah.
All right. It's time for a special guest appearance, folks. Here it is. Here's the truck. Here's the truck driver who's been keeping false records. That's the fact we're trying to prove. False logbooks. And here are two other people. What a diverse mix of people we found. Isn't that great?
It's fantastic, mate.
Okay.
You're pretty excited about this part, aren't you?
I am. So let's keep this really simple because I find the hearsay rule, I get tangled up on this one myself because I don't deal with it all the time. And each time I come back to it, I get all tangled up. So let's call them A, B, and C. We're trying to prove that A has been keeping false logbooks. He tells B, I'm keeping false logbooks. It's so easy. Waka Kotahi are idiots.
They'll never catch me.
B comes along and tells C about this, what she's heard. We catch up with C, and we have a statement from C who says, B told me that A told her that he's keeping false logbooks. This is hearsay.
It's hearsay.
Yeah.
Now, 100% good example. Hearsay only applies in court. So I often hear people talk about, we can't do anything with this, it's hearsay. It's only hearsay when it comes to court. That's the only time it actually applies.
Yep.
All right. Up until then, think of it as evidence that you haven't yet corroborated.
Mm-hmm.
So in this case, the evidence of C doesn't have a lot of credibility because it could be lost in translation. It's not first-person account of what happened. So go and talk to B. B's evidence is reliable.
Yep.
You know?
So if C was the only person we could have as a witness, we would probably be in trouble in court.
We wouldn't be able to use C, yeah.
If we've got B, she's a witness. But what is she a witness of, Paul?
The conversation.
The conversation. So she could help us prove the fact that A told her he kept a false logbook.
But not that he kept false logbooks.
Not that he kept a false logbook. But if we've got other evidence and other circumstances that we could build up a picture that does prove that A kept false logbooks. So that's the thing to think about with hearsay, which is when you've got that scenario, A, B, C, who is your witness?
Yeah.
If your witness is B, you're probably okay. If your witness is C, you might have to do some more work for it to be admissible in court.
Yeah.
But you can still use it.
And ultimately, your best witness is A.
Yeah. Yeah.
And their confession.
Yes. Yeah, but let's assume that A has gone to ground.
Okay.
Because he knows we're after
He knows he's in trouble.
Yeah. So the other thing I hear about with hearsay
Yeah.
is this thing called the documentary evidence rule.
Yeah.
So let's use a different example. This truck goes across that weighbridge at 9 o'clock at night, and there is a weighbridge. There's a record kept that.
Let's use a port. I think it's probably an easier
the port. Yep. So the truck goes through the port at 9 o'clock at night
every day.
The port keeps a record of that.
Yep.
So how does this work with documentary evidence?
A is driving the truck into the port every day. I'll need these two characters.
Oh, right.
As part of the routine business of the port.
Yep.
Our port worker here. G'day, A. How you going? I'm going to record you coming over our weighbridge, and I'm going to log that you were here and log the weight.
Yep.
Thanks. Right. Along comes the careful investigator from Waka Kotahi.
Yeah.
Who says, hey, I think, A's been up to something dodgy.
Yeah.
And gets a copy of those records through whatever means. All right. So they obtain those records. Now, ordinarily, B would have to go to court and say, I made these records. They're all correct. They were on this day. That was the driver.
I'm the witness to the fact that went over the scales. Yep. This is what the scales read. This is what the time was.
Now, there's this really cool thing they brought into the Evidence Act, which is about documentary hearsay, because technically that's hearsay. The documents themselves are, if we produce them in court. But because of that provision around documentary hearsay, the careful investigator from Waka Kotahi can produce those and say, these were records that are kept in the ordinary course of business and they're admissible. Now, and that means that we don't need B to come to court at all.
Yeah. And the point is, is that B does this every day, every week. Her memory of that particular truck going over the weighbridge is not going to be very good. All she's going to be able to tell the court is what she normally does. Therefore, she trusts her records. Yeah. So that's what the documentary evidence rule is about. Yep. Records kept in the ordinary course of business where basically there's no benefit in having B turn up as a witness because we can trust the records.
Right. Now let's talk about the chain of custody in this.
Yeah.
So the careful investigator from Waka Kotahi goes along and says, here's my power to obtain those records, or here is my, we've agreed that you'll give them to me by consent. The careful investigator will take a very short statement from this witness to say, I work at the port, I collect the documents, this is how that information's recorded.
Yep.
And on this day, I gave to the careful investigator 542 pages in a electronic format.
Yep.
And then the careful investigator takes that electronic format back, makes a copy, and then secures it. Let's say it's a memory stick, secures the memory stick because that is the evidence.
Yes. Yeah.
That's the evidence.
Yeah. So if you've got dealing with business records, deal with them with confidence. You don't have to get too worried about the hearsay rule.
Yep.
And also the other one is land data or the motor vehicle register, where we have vehicle inspectors all around the country punching in odometer readings and other bits of data. They are really the witnesses of what that odometer said on that day. But the starting point is we've got a good business record of that.
Can I make a comment that made about the Privacy Act?
Yep.
So there's a principle in the Privacy Act that says you use the information for the purpose that you captured it.
Yes.
Right. But the courts will always say, we want the full narrative of events. So it would be unusual to get up and say, oh, sorry, we can't tell you that part of the story because we didn't collect the information for that purpose. So when you start to get into this offending type thing, that changes.
Yeah.
So don't get too hung up about Privacy Act stuff.
Yeah.
Be mindful of it and get some advice.
Yeah, in this context, the Privacy Act is about storing that personal information securely and sharing it on a need-to-know basis.
Yeah.
But there are lots of exceptions in the Privacy Act.
Principle 11.1e.
Yeah, and doing this kind of work is one of those exceptions.
Yeah.
Okay, final thing I wanted to say was we've talked about what is evidence, when do we need it, how do we collect it and look after it. We've then gone into a few technical rules, best evidence, hearsay, documentary evidence. The final technical rule I want to talk about is legal privilege. And this is something that's helpful for us. There is an excellent webpage on OnRamp explaining what legal privilege is. But there are two types. One is called litigation privilege, and that protects information that we prepare when we're getting ready to go to court. Very narrow, not particularly helpful. If you're thinking of relying on that, please talk to the legal team. The more common one is legal professional privilege or solicitor-client privilege. And what that means is communications with lawyers and from lawyers to their clients are privileged. What this means is if you send the legal team an email, ideally your email says, I need some legal advice, please, rather than just general chat that you might have with any other colleague. Your emails to the lawyers and their replies will be privileged. Inviting a lawyer to a meeting, the stuff that the lawyer says in that meeting and the specific questions you ask them will probably be privileged. But again, general chat in the meeting might not be. It's about whether the communications, whether that dialogue is for the purpose of getting legal services.
Yeah. If I could
and don't just copy lawyers into emails and think that will privilege it. Yeah. I think we've mentioned that in a previous video.
So if I could just, from a practical point of view, I think privilege is often seen as this big protective cover. It's not. Work on the basis that everything you say and do and write down one day could come out in a judicial setting.
Yeah.
And there are times when the privilege itself will be challenged.
Yeah.
And then often the court has to see the evidence to decide whether or not it's privileged. So just everything you put down, keep it really professional and work on the basis that one day someone's going to get to see it.
But actually a good example here is in any of these scenarios, you could email your lawyer and say, hey, do you think this evidence would stand up in court, or would this evidence be admissible? Those conversations, as long as you keep them focused on that subject, they will be privileged. Yeah. The other thing we have to be careful about is waiving privilege. So the idea with legal privilege is that it applies to confidential communications. So we have to keep it confidential. If we share our legal advice or legal discussions too widely, we can waive privilege. So particularly when we're using consultants and contractors, just think carefully about sharing it with them and make sure they understand that they're receiving legal privilege material and they need to keep it confidential.
And am I right in thinking that if we waive privilege, intentionally or not, it's waived?
It's waived.
They can pass it on to anyone they want.
That's right.
Yep.
So if we are careless with our confidential privilege material, then generally we've waived that privilege and we've lost that protection. So you can't have your cake and eat it too.
Yeah.
Essentially.
So I think
it's
that's
confidential or it's not.
I think that's something you need to keep, just one of those things, keep in the back of your mind. So be alive to the issue and get advice when it comes up.
Yeah.
Because every case will have its own nuances and be a little bit case specific.
Yeah.
So just go and ask the legal people.
Yeah. Thanks, Whānau.
Thank you very much, everybody. Next week, we're going to be doing our compliance response framework and talking you through that. Ka kite anō. Oh, hey guys, just one more thing that I forgot. If you need any legal advice, go and see Henry. Thank you.